Statute 83.682. 1. Any service member may terminate his or her rental agreement by providing the landlord with a written notice of termination to be effective on the date stated in the notice, which is at least 30 days after the landlord's receipt of the notice if any of the following criteria are met. A. The service member is required, pursuant to a permanent change of station orders, to move 35 miles or more from the location of the rental premises. B. The service member is prematurely or involuntarily discharged or released from active duty or state active duty. C. The service member is released from active duty or state active duty after having leased the rental premises while on active duty or state active duty status, and the rental premises is 35 miles or more from the service member's home of record before entering active duty or state active duty. D. After entering into a rental agreement, the service member receives military orders requiring him or her to move into government quarters, or the service member becomes eligible to live in and opts to move into government quarters. For purposes of this paragraph, the term government quarters means any military housing option that is available to a service member, including privatized military housing that is owned, operated, or managed by a private sector company. E. The service member receives temporary duty orders, temporary change of station orders, or state active duty orders to an area 35 miles or more from the location of the rental premises, provided such orders are for a period exceeding 60 days. Or F. The service member has leased the property, but before taking possession of the rental premises, receives a change of orders to an area that is 35 miles or more from the location of the rental premises. 2. The notice to the landlord must be accompanied by either a copy of the official military orders or a written verification signed by the service member's commanding officer. 3. In the event a service member dies during active duty, an adult member of his or her immediate family may terminate the service member's rental agreement by providing the landlord with a written notice of termination to be effective on the date stated in the notice that is at least 30 days after the landlord's receipt of the notice. The notice to the landlord must be accompanied by either a copy of the official military orders showing the service member was on active duty or a written verification signed by the service member's commanding officer and a copy of the service member's death certificate. 4. Upon termination of a rental agreement under this section, the tenant is liable for the rent due under the rental agreement prorated to the effective date of the termination payable at such time as would have otherwise been required by the terms of the rental agreement. The tenant is not liable for any other rent or damages due to the early termination of the tenancy as provided for in this section, notwithstanding any provision of this section to the contrary. If a tenant terminates the rental agreement pursuant to this section 14 or more days prior to occupancy, no damages or penalties of any kind will be assessable. 5. The provisions of this section may not be waived or modified by the agreement of the parties under any circumstances. We offer real estate, estate planning, probate, and business law. Call 321-206-3603 or visit easlerlaw.com to book a consultation. Offices in Melbourne, Florida. Virtual consultations worldwide.